to the definitions, which great. Welcome back. We're now on page 15 of at H211, the data broker bill. And the tissue box is exploding. So we're doing a walkthrough date with our legislative council.
Right.
Rick Sagel.
Yes.
Rick Sagel won. Go for it.
Yeah, Rick Sagel with the Office of Legislative Counsel on page 15 of H211 as passed by the House. Do you want me to share my screen, or you weren't really looking, so I can?
Thomas was.
Okay.
How do you prefer it?
I'm looking
We
on the
have it
laptop.
all
It's an either or.
in front of us, and
It'd
so
be
we don't
easier.
need to-
It'd be easier if I had my own.
Yeah, let's do it.
Okay.
Let's just keep doing it.
All right. So section 2431, currently in law, but there's a pretty big addition to it. This is the credentialing piece that Ryan mentioned. So currently there are some prohibitions against page 15. Yep. Prohibitions against acquiring broken information for fraudulent purposes, stalking. You see the other reasons, and this is a person, so nobody can acquire this information with these ulterior groups at current law.
Let me just check one thing,
Yeah.
that although we may have our own copies for the public to follow along.
So the public, it is available online.
But-
It is posted. Is that
But
correct?
looking at it online and trying to see
Okay.
what happened here, a video is.
That is fine.
No problem.
Good idea. Randy,
It makes my face
Far more
thought. So, right.
from the chair.
Yeah, let's you guys see it. All right. So subsection B. This is new.
Yeah.
Disclosure. So this is for the first time now. This is Vermont regulating directly data brokers. The current law says you should not, anybody should not acquire for fraudulent purposes, etc. This is specific things that data brokers now cannot do or have to do. They shall maintain procedures that require prospective users of the data broker's brokered personal information to identify themselves, state the purposes for which the information is sought, and certify that the information shall be used for no other purpose. 2, prior to disclosing the brokered personal information to a prospective user, make a reasonable effort to verify the identity of the prospective user of the information and review the user's stated purposes for which the information is sought. And finally, not disclose brokered personal information to a prospective user if the data broker has reasonable grounds for believing that the information will be used to violate state or federal law or will not be used for the purposes stated by the use pursuant to the subsection. So this is just a piece requiring data brokers to be more careful when a user wants to purchase or acquire information they are selling or sharing, that they do their own due diligence to ensure that information is not used for unlawful purposes.
Right.
Okay, so subchapter 2, changing this currently, it is Security Breach Notice Act. However, because we're adding a new security breach notice provision, the subchapter is broadening to just security breaches. So 2435, section 2435 is the current notice of security breaches. This has been law for several years.
Sorry, just to back up, remind us, it's DFR that is required, is the
And the AG.
and the AG to require that notifies the public in Vermont if there's a data breach.
So anyone who's a data collector, it's a pretty broad definition.
Right.
If you're a data collector in the state,
The state is that.
it is. State governments are included, unlike data collectors.
Right.
If a data collector suffers a breach and they meet the requirements of what the breach is, they must notify the consumer within, I think, 45 days, and the AG within, I think, 14 days. That's current law. That's not changing.
Right.
If it's a non-financial institution, it's the AG that enforces. If it is a financial institution that's regulated by DFR, DFR enforces this section. Okay, now there are some changes to this. Technical change on page 17 email, just technical grammatical change. Telephone notice. So when you inform the consumer there's been a breach, they are allowed to use telephone if they have the information. I think it was DFR that testified that sometimes this privilege is not used on the up and up, that they'll leave a voicemail without really trying to contact the consumer, that there's been a breach and the consumer doesn't get the voicemail. So there's some beefing this up a little bit. So telephone notice for consumers who the data collector has a valid phone number, provided that the telephone contact is made directly with each affected consumer and not through a pre-recorded message. That's current law. And further provided, new law, that the data collector makes not less than 5 attempts to contact a consumer for a live conversation, or the data collector, may leave a voicemail providing information about the breach. So testimony you may have them into is that consumers sometimes didn't get the notice, that they didn't check their voicemail. In this case, it must be at least 5 attempts before they leave a voicemail. Adding a subsection heading, no change to the substance in C and D. On page 19, another subsection heading, typical compliance. Adding a little bit more information here.
HIPAA?
Yes, on page 20. So if the data collector says they're subject to HIPAA and their notification requirement is different because of federal law.
So a hospital. This would fit a hospital.
Sure, or some other.
Or a doctor.
Right. So the change is on top of page 20. They must provide notice to the AG or DFR, along with a certification that they comply with HIPAA, the underlying federal law. So you're allowed to have different notification requirements that are breached. However, you also must be compliant with federal law. And our government wants that information that you are compliant with HIPAA. If you use that as not excuse, but if you use that to not follow the notification laws as written. Right. The other change, subsection headings, waiver, financial institution. This is somewhat of a major change on the enforcement, the DFR enforcement.
So this is also an area that Ryan is wanting to further chat with us.
So subdivision 2, this is the DFR piece.
Right.
With respect to a data collector that is a person or entity, current
This is just in the breach, right? This is just with the breach.
Yes. Yeah.
And DFR is responsible for notifying us on financial breach.
Yes. Yeah. So the current language is an entity licensed or registered with DFR. And they testified there's a gap there, that sometimes you have an entity, perhaps out of state, that has Vermonters data. Right. So they may not be licensed or registered, but they are regulated by DFR because of what they do. So DFR thinks you change that to regulated by, that would fill the gap. Okay. That's the change to Security Breach Notice Act. 2436 on top of page 21. This is a new section that is very, very, very similar. A lot of us copied and pasted from the Security Breach Notice Act. The Data Broker Security Breach Notice Act. Most data brokers, maybe all of them, are also data collectors, because data collectors is a very broad definition. However, this Breach Notice Act is brokered personal information, not personally identifiable information. Now, these things may be similar. If you go back to the definitions, you can compare the two.
So this is brokered personal information.
Yes.
Device.
Yes, that's part of it.
And then you said not personal. Were the two categories you just?
So you have brokered personal information, which is mostly data broker in that field. Then you have personally identifiable information, which is specific mostly to the Security Breach Notice Act.
Okay.
So,
This
and
is personal information, right?
this is brokered personal information. Yes. So this notice act is for if a data broker has a security breach that is not encrypted. Same language that you have in the Security Breach Notice Act. But if there's brokered personal information that gets breached, they must notify the consumer and the AG in the same timeline. So 14 days for the AG, 45 days for a consumer, unless there's some type of law enforcement activity. It's almost word for word the same as the current Security Breach Notice Act. So I don't think I need to read this entire section. There's nothing hidden in here that,
So what is,
intentionally at least.
what is a consumer to do? I mean,
So there's
it's
enforcement.
great that consumers would be notified if the data broker that has their data is free, but what are they supposed to do about that?
Well, so knowing that there's a breach, you can freeze
You
the
could
credit
delete
report. Yeah, there's things you can do. You can get an identity theft company that watches your information, lets you know if your information on the dark web. There are things out
So
there you can do.
you can actively look and see
Yeah.
if your information has been, how would you even?
Well, companies have the tools that scan those dark websites and other entities. In fact, sometimes those companies will give you a free year subscription if your identity's been compromised. They'll send you a year free of credit reviews or identity theft reviews. That's up to the company to determine.
So I think that for us, as we convey this to our constituents, it would be good to know all that kind of thing going
Yeah.
on. Okay,
And
sorry.
you should maybe get testimony, right, from
Absolutely.
either a consumer watchdog that would know.
Yeah, I might be
Best
sitting
practice.
behind you.
Okay, so I'm going to skip down. That's okay. There is here. One thing I want to highlight, the Attorney General had added. Okay, so there is an exception which exists in the regular Security Breach Notice Act as well, that if the data broker in this case establishes that misuse didn't happen. Like we had a breach, information was available that was not encrypted, however, nothing was compromised. That's an exception to the notice that your information was public briefly, but nothing was compromised.
And the exceptions begin where?
On page 26, bottom of page 26, subsection C. So the language is similar to the data collector language. However, in this case, the Attorney General requested additional information if the data broker chooses to use that exception. I'm on page 27. They must send to the AG a summary of their determination that misuse of the information didn't happen. On line 8, upon review of the data broker notice and detailed explanation, the AG may request additional information from the data broker and may accept or reject the data broker's determination. If the AG rejects the data broker's determination, the data broker shall provide notice of the breach pursuant to subsection B. So that's different from the underlying Security Breach Notice Act. Okay, everything else, enforcement in this one is under the Consumer Protection Act. The enforcement under the regular Security Breach Act is just the AG, enforcing through their own rulemaking or through the language in the bill. So that's also a little bit different. This is through the Consumer Protection Act.
This is still for breaches.
So yes, it's
Question.
Yeah.
And that is for a violation of a breach of this kind that affects a person. They have the individual right to sue. Is that correct?
correct through the Consumer Protection Act.
Yeah, the same as.
Yep. Student privacy, no substantial changes. However, I noticed a technical error is I showed you the chapter 62, right? How all the things, kids code, all these things are in there. So the current enforcement and the student privacy is I think it's 7-8 years old whenever this you all pass this. It's about advertising to students.
8 years ago.
It's been, I don't know.
Hard to
That's
believe.
my guess. I'm trying to remember the
8
year.
years.
Okay, yeah.
No, that's what Ryan is so important. These digital and institutional memory here.
Yeah.
Because he and I were here in this room doing it.
So there's no change to the language except the enforcement. Currently, it says a person who violates this chapter commits an unfair deceptive act, which I think is not intentional. However, it opens up the entire chapter to the Vermont Consumer Protection Act, which I don't think was the intent
Right.
of the General Assembly. So correcting that to subchapter and then adding in rulemaking, which was also missing. The AG has a rulemaking in that area. I think you probably need to give it to them and House Conference agreement.
Yeah.
Okay, page 29, that's the data broker, and the rest of the bill is specific to data brokers. So if you want to get in that frame of mind, here we go.
Great, we're shifting to data.
Specific to data brokers. Yeah, exclusively. Okay. So as Ryan and Monique both mentioned, data brokers must register with the state. That's current law. There is a number of changes to this. They still must register. However, the timeline changes. Currently, they must register once a year on or before January 31st, following the year in which they operated. So if the data broker starts business today in Vermont on April 8th, they wouldn't have to register until January 31st of 2027. So there could
There's a
be,
big lag.
could be, right.
Yeah.
So this would adjust that gap to where you'd have to register within 30 days of operating in the state. And then once annually, on or before July 1 of each year. That's new. Number two, the registration fee goes up quite a bit from $100 a year to $900 a year. They must maintain a bond of $20,000 that runs to the
And
state.
that's a significant leap.
That's a significant leap.
And I suppose we can hear further from, was there a reason given for that leap? Is it costing DFR that much to do this work?
So it's
Should we have
Secretary of
DFR
State.
testify on that? I guess I'm just,
Secretary of State.
oh, secretaries. Okay.
The introduced version contemplated a deletion mechanism, which would cost money. There's no deletion mechanism. However, there's a study, as you'll
Right.
see here in a little bit. So yeah, if you don't think the numbers,
No, I just think we need to appreciate why they've grown so significantly. I mean, this was only 8 years ago.
right. Number three, maintain a bond of 20,000, which would run to the state for any liability under the subchapter. You'll see why that's important here in a second. Subdivision 4 is huge, providing the following information to the state. So currently, they just have to provide their name, their address, their phone number, and a few things about whether they allow consumers to opt out of their databases. So this is probably too early for this, but in subdivision A, there's a grammatical change I need to make to that. So
So,
if you,
are you going back to page 29?
I'm on page 29,
Yeah.
line 14. So just, it's not worded correctly. I need to because it's not the name and primary physical phone number. That doesn't make sense. I need to rearrange those words so that it's
Primary physical address.
right. And then phone number will be separate. It'll be saved.
Got it. Okay, isn't it nice to know that it left the house imperfectly?
So if you want to amend the bill, I would ask the committee consider that.
Right, we could, yeah. Okay,
All right, subdivision B comes back later in a different form, so I'm gonna skip over B, which being struck through. C also comes back in a different form. D remains. C remains. E is brand new. Whether the data broker collects the, and you have a lot of details here, but mostly sensitive information, precise geolocation, reproductive healthcare data, fire data, immigration status, sexual orientation, union membership status, the name, date of birth, zip code, email address, or phone number of consumers. And this is just yes or no at this point.
Just for clarification,
that's, oh, sorry, Dave.
reproductive health care data, such as, just an example.
So, yeah,
Sure.
you missed Brian's testimony that said one of the concerning things was that at one point, one of the data brokers was selling the geolocation of patients who were going into reproductive health care centers.
And I thought we addressed that in previous bill. I was just wondering. This was like
This is
3
still-
years ago. There was a geofencing issue.
We had that with Kids Code that we addressed, and there is some in data privacy, but I think for this is not selling that information, so we're addressing
Okay, I
the
just
third party piece.
Want
Yeah.
to make sure I understood what.
And it's whether they actually collect it. It's that's where we're at right now. Is they're not prohibited from collecting it.
But they can sell.
Well, no, this is just gather information.
Oh,
Yeah,
okay.
we need to make sure we understand the world that this bill exists in. I'll make that clear as we finish up the bill. So right now, this is just, do you do this? Yes or no, right?
Oh, right, this is for the registration.
Yes. And maybe eventually the state wants to regulate that, but account login or account number of consumers, in combination with any required security code, access code, et cetera. Some kind of government ID, driver's license number, state ID, social security number, passport number, et cetera. Mobile advertising number, connected television ID number or VIN of consumers. In the past year, has shared or sold consumers' data to, again, this is yes or no, a foreign actor, federal government, to other state or local governments, to law enforcement, unless it was shared pursuant to a subpoena or court order, to a developer of an Gen AI system or model. F, on top page 32. The three most common types of personal information that the data broker collects. If the data broker does not collect the information set forth in 7 and 9, which is, show you this right here. So it's data, the name, date of birth, zip code, email address, phone number, and then the government IDs.
Right.
An electronic copy of the data broker's bond and their current privacy policy.
So if I can.
Yeah, David.
So going back up to F at the top of page 32.
Yep.
So what's this, all these categories of things which could potentially be shared. But this F is really a question of, well, if it's not all of those, this is what we do. Is that the point of the paragraph? That
What are you selling the most of? What are the
Right.
three most common areas of that you collect? Not that you sell.
what's the rationale?
It's probably not a question I can answer. Yeah.
We can ask the committee. We have to ask the committee. Let's put them in it. We'll ask.
Thank you.
So on page 32, what they must provide during registration, the URL of the page on the data broker's website that allows the consumer to request that the data broker delete their information. More about that in a little bit. And informs consumers about the rights of consumers to opt out of the collection of their brokered information, including whether they permit the consumer to opt out of the databases or opt out of certain sales, the procedure for requesting an opt-out, if the opt-out applies to a certain activity or sales, whether the data broker permits a consumer to authorize an authorized agent to perform the opt-out, the data collection, databases, or sales activities from which consumer may not opt out, and whether and to what extent the data broker or any of its subsidiaries is regulated by the Fair Credit Reporting Act. Finally, they also have the authority to amend an existing registration if required by the state upon an administrative fee of $100. Okay, penalties.
So this is all over. For some unknown reason, I thought this was overseen by DFR, but it's overseen by the Secretary of State. That's who they register with.
Correct.
Right.
Which is not common. It's one of the few things that, they register businesses. I think that's how in 2018.
Right. So with the natural. Right.
Yeah, but DFR
Just
has most other of these regulations. Penalties. So striking through the current penalties, which is $50 per day for failing to register, not exceeding $10,000. So struck through. Just letting you know what the current penalties are. New language, instead of 50 per day, if a data broker that failed to register as required, an administrative fine of $200 for each day, and an amount equal to the fees that were due during the period the data broker failed to register, and then any reasonable costs incurred by the state in their investigation. A data broker that fails, subdivision 2 on the top of page 34, that fails to provide all information shall upon amendment within 30 days of discovering or being notified if their registration is not complete and is liable for $1,000 per day penalty to the state. A data broker that files materially incorrect information in its registration shall be liable to the state for a civil penalty of $25,000 and correct that information within 30 days of discovering it or be notified that it's incorrect, and a penalty additionally of $1,000 per day that the bill state to correct the information. So you see the bond of $20,000. That's why the bond is in House Congress's mind required, because you have these higher fees or these higher penalties that could add up very quickly. So if there's a bond, the state would like that to be billed. Okay. Subsection C, top of page 10, deleting broker personal information.
So good to go back to the face.
Yeah.
The Secretary of State was the entity that's was increasing these and asking for these increases. Am I right?
The bills introduced had high fees. You can ask them if they
So we'll
agree. Yeah.
look at Monique back and David.
Yeah.
Okay, great.
Deleting, this is new. Again, this is more regulating data brokers, which Vermont has not done before. This is new stuff.
Sorry, where are you now?
Top of page 35.
Yeah.
A data broker shall maintain a conspicuous page on its website where a consumer or their agent has the ability to request that a data broker delete their information free of charge. Big requirement, right? So now every data broker that registers in the state must have that, give the consumer that capability. Delete the consumer's information not later than 30 days after they make that request, unless there is an exception, which I'll get to in a second. And then notify the consumer that their information has been deleted within 5 days of that deletion. Subdivision 2, that web page maintained by the data broker shall describe how a consumer may exercise their rights to delete, including the process for an appeal if they get denied. Adhere to accessibility and usability guidelines in line with federal law. Page 36. Employ design practices that facilitate easy comprehension and navigation for users and that are free of dark patterns. So don't make it tricky so the user can fairly easily request that it be deleted. Subdivision 3. A data broker may deny a consumer's request to delete the consumer's information to the extent that the use case exemptions that Rep. Priestley talked about. The retention of the consumer's brokered personal information is required by law, or is required to comply with a civil, criminal, or regulatory inquiry, investigation, subpoena, or summons by a government. Or the brokered personal information is used by a consumer reporting agency to furnish a consumer credit report pursuant to the Fair Credit Reporting Act, necessary to investigate, establish, exercise, prepare for, or defend a legal claim, strictly necessary to fulfill a specific legal requirement on behalf of the business to which the data broker is bound by a written contract of a legal requirement, used to prevent, detect, protect against, or respond to security incidents, ID theft, and a few other security issues. Page 37, data that is collected or used for purposes of the National Precursor Log Exchange or an equivalent. That is the Sudafed. When you buy Sudafed from the pharmacy, they have to have your ID. If you bought Sudafed recently,
They don't record it. They just look at it and then sell it to you.
well, there's that information is in a computer, right? And they check your ID, how many times have you bought this information. So that is exempted. That process is exempted. Process solely in the data broker's capacity as a processor to a business with which the consumer has a direct relationship. And we have that defined earlier in the bill, what a direct relationship is. Or used in connection with underwriting, issuing title insurance, or completing an appraisal. Any questions about that? So those are exceptions to deletion. Every data broker that meets the definition has to enter as a data broker in the state. These exceptions are, you don't have to delete the consumer's information.
Right.
Okay. Number 4, brokered personal information that is retained must be A, separated or segregated from the data used for any other purpose, deleted immediately upon the expiration of the requirement, and then not used, sold, or shared or processed for any other purpose.
Okay, sorry, we just lost you. We were explaining the Kleenex box explosion.
Okay,
Where
so
were,
number four, that if the data broker does keep the data, that if there is an exception and
right,
they don't delete it, it must be ABC, segregated, separated from other data used.
separated, got it.
ABC, deleted immediately upon the expiration of that
Got it.
requirement, and then not used solely for any other purpose.
It's okay, my
Okay.
we're really like covered.
10 more minutes, so let's try and see if we can finish this baby.
I can make a lawyer joke about maybe Entra.
About the
Yeah,
exploding
yeah,
Kleenex box.
yeah, sure, sure.
Well, maybe IT has like one of those.
Oh, I bet you do.
Air
You're doing this,
blast.
Eric. We're
Okay.
about to break. So 10 minutes.
I got this. Yeah, this is so 7.5. A data broker shall provide the consumer with the ability to appeal an instance where the data broker denies the consumer's request to delete with a process that gives the consumer 45 days after they receive notice to initiate the appeal. Page 38 is conspicuously available to the consumer and is similar in which to the process which they submit originally their deletion request. Requires the data broker to approve or deny within 45 days after they receive the appeal and to notify the consumer in writing of their appeal or their decision. And requires the data broker that denies their appeal to provide information that enables the consumer to contact the AG to submit a complaint. 6. If a data broker is unable to authenticate a deletion request, in other words, they don't know if it's actually you requesting it or your authorization.
Right.
The data broker shall not be required to comply with the request and shall provide notice to the consumer or their agent that they're unable to authenticate. The data broker shall provide the consumer with the additional information that they require in order to authenticate the consumer. And we have how authenticate is defined. D, this is the Senator Brock, the consumer rights webpage that the secretary has to create. On page 39.
Sorry, the who?
The Secretary of State must create this consumer rights webpage.
There
The
it is.
Secretary of State shall create and maintain a publicly accessible page on his website that provides consumers with the following: a downloadable spreadsheet of data brokers that have registered, along with the information that they provided during registration, or they collect that information. Yes, no, whatever.
Right.
The URL of a page on each registered data broker's website that allows the consumer to delete their information. And then any additional information about the rights consumers have pursuant to the subchapter. And that's, if you want to beef it up, that's where you would want to beef that up, subsection C or subdivision 3.
Great.
Enforcement is through the Vermont Consumer Protection Act. So again, AG enforcement, and yes, consumer, if they're harmed, can sue a data broker as well. 2447 is a technical change. This is other data broker requirements that are currently in law. The change of the enforcement provision, again, I think mistakenly, it gives the entire chapter rulemaking. It's just meant to be that section.
So you fixed that, I assume.
Yeah, striking through section.
Yeah.
Starts striking the chapter, and instead it's just the section. Okay, final section 2. I don't know if I mentioned this. I think Brett Priestley did. The bill originally required the state to create its own deletion mechanism, which was going to be huge.
Oh,
Correct.
yeah, it's
As
already
introduced.
identified.
As introduced,
8
right?
million was 3 years ago.
Yeah.
Yeah. So that was removed in House Commerce.
And instead we have the study.
And well, and then you have the consumer having the right, but they must request it through the data broker, not through the state. California's you go to the state. Easier for the consumer. But here
Well,
the
that's what
bill,
we're hoping to do is make things easier.
here the bill still gives us a right that you have to go through each data broker, right? So in this case, the bill asked the Secretary of State to have the capability of creating websites. And the language is almost taken verbatim from the bill as introduced as to what, and you can kind of see what the bill would have required the mechanism to do. So I won't read this, but it's just basically, we want consumers to be able to do this. One request, every data broker delete, minimal clicks. Is this possible? Is this
Right.
real? Okay. And then at the very end, this is still the study. It's due on or before Interim report is due December 1, 2027. Final report, December 1, 2028. Because this is a big study. This is going to take a while.
Yeah.
They are going to talk to California. They're going to do their own research. They've asked for an appropriation. That's on the last page. To hire a consultant to help with that study. That's their testimony. David Hall requested an appropriation. So 50,000 would be appropriated. And this did make it to the budget. My understanding.
This did,
My understanding is House appropriation said there's room for this in the budget.
yeah,
So
How much money?
50,000.
for a 2-year study.
The Senate may disagree, right? That's my recollection of what House
Well,
appropriation.
for here for Dave Paul,
Yeah.
it's an expensive addition for them to oversee.
And it would take effect, so January 1, 2027, to give some time to update their registration system. Because that part would take effect in January, the ability for consumers to view the data brokers registered and to have their information deleted. With 7 minutes to spare, that's
I'm
voice is
impressed.
almost gone.
You took the full time we needed, David.
So I missed about 30 minutes of a presentation this morning. You guys may have covered it. Kind of going back up to about 40,000 feet.
Yeah.
Roughly how many data brokers affect Vermonters?
well, 290 is the current
So
number.
300-ish.
The argument, I don't know if this is true. but
Two
there are-
19 are registered at the moment, but the argument is that there are over 700. 750 exist and 450 may be missing from our registration.
Okay.
And part of what we do here, I think, is make it tighten up the who needs to be registered.
Huge penalties, huge
Yeah, if you
penalties for not registering.
And how does the individual Vermonter know that data broker A, B, or C has access or to their data? I mean, how does I understand the
How does
whole
the
concept.
consumer understand this?
I think it's part of the problem, right? The consumer, we don't know, most of these are not household names, the data brokers that exist. Like LexisNexis is one we all know, but a lot of these are not known brands.
Binary in the
So-
room, LexisNexis,
Yeah,
right
they
there.
make themselves known, right? But a lot of these companies, we don't know, quite frankly. So
How does the bill affect them?
So the Secretary of State provided that spreadsheet of here are the data brokers that are registered. And then so you click the link, you would give them your information.
Each 700 odd.
Right.
Well, that's why we need an easier system for how to delete it.
And then you would type in David Weeks to whatever they need to have to authenticate you. And I've actually done this with a few of them.
Oh, great.
Who's authenticating who? They're authenticating the consumer going in.
Right. And if they have your information, they may not. But if they have it, then they would email you back probably pretty quickly and say, you deleted it, or we don't have your information. We can't find your information.
Or I think what David is asking also is what information of land you have and are you collecting?
Yeah. That you may not find out, but
That may be harder.
No, I'm just, so it's kind of actualizes.
Yeah.
You know, how does, if you just take Joe Schmuckatelli out of, the hills somewhere,
Yeah.
how does he know? He doesn't. Who's really looking at his data? I'm just curious.
Well, I think we may have some answers too on some of that because some of that is known. Zach is nodding his head and he's going to testify next
Okay.
week, but I think that some of that is known. So Zach, if we could answer that, that would be great.
Or you can spend $59.99 per year to Norton.
Right. Inside. That's
there's
right.
services like that.
Who's collecting? So-
600.
We have 4 minutes left. Thank you, Rick, for
Oh,
getting
sure.
through it. And thank you. We're going to hear from anyone who would like to testify about this is Dylan, Jamie, and Zach, and Chris and Bridget. No, but I'd like to turn to our Vermont Law School, our UVM student who sat in on some of this work. Would you just introduce yourself briefly and say why you're excited to hear this discussion of this work?
Yeah, I did a little bit of
What's your
research.
name?
Oh, my name's Kevin McGreal. I work for the Vermont Legislative Research Service, and this was one of the bills my team looked a little bit at. So for me personally, I'm here because this issue is very important to me, and I just want to see how it tracks.
And why is this issue important to you?
Because I feel like our personal data is really important, and we should have control over that as consumers. There's so much that goes on behind the scenes that ends up affecting our lives in many ways that we don't even know. And personally, I don't like the idea of that. And I think taking steps to regulate that and having more control of that is really important.
Well, we're delighted you're here. You're also interning with somebody here in the building?
Yes, I'm interning with Representative Esme Cole.
Oh, great, terrific. One of our-
So can I ask, what data concern like keeps you up the most at night or gives you the most anxiety, and does this bill solve it?
Oh man. I mean,
It's a
location.
question we
Yeah,
should
yeah.
ask ourselves.
Yeah, yeah,
because we're moved by
Definitely like location data and like the personal identifiable information, just so like, I don't know, I hadn't prepared anything.
No, that's okay.
Yeah, yeah.
We're-
So I
I
think
just, I've only
this is
been.
our-
the location is a big one for me,
Even if you-
honestly. Just like knowing where I am, knowing what my habits are, just feels like close to me. I don't think targeted advertising. I don't like, just like seeing stuff coming out of nowhere. And then also the potential for price discrimination is kind of
Oh,
a big deal.
Mhm.
we've talked
Um,
about that.
Just because, we're already limited, we're getting more and more limited in like where we can, as much as like things have been expanding, it feels like things are also contracting and like what we have options to buy from. And I don't know, that seems like we should
Well,
do
those are-
something about that.
Well
Those are
said.
three good reasons. Those are,
You have to scare young people a little bit, so when they run for office, they know what it's
yeah,
like.
no, that's why I wanted you to just to weigh in, because it's great that and it's the UVM's, what's it called again?
Yeah, the Vermont Legislative Research Service.
That's right.
It's still Brzezinski.
He's on sabbatical. It'll be Professor Doc Bradley running it next semester. Yeah.
Oh, that's great.
So don't forget, when you see the emails, put in the requests
Yeah.
for research. We do
Exactly.
good work.
You may have put in this request. I don't know who put in this request.
This
You
was
know?
Monique,
Oh,
Representative
Monique.
Priestley.
Big surprise.
I have my own housing, and they do take a loan.
Yeah, they do. So we appreciate it. We also get the same request from Tuck.
Mm.
And it just takes a long time for us to get feedback, and it's not necessarily in our time frame.
Yeah.
So we need it generally January through March is most
Mhm.
useful, and we're getting it in June. So
But when you show up, because it's always not on our time frame, it's always the fall.
Mhm.
Like when you show up, ask to testify, like
Yeah.
ask to share your research, because that does make it far more useful to us than someone getting a report and whether or
Yeah.
not they forwarded to them.
no, and I'm so grateful to you for just coming today on your all on your
Thank
own.
you.
So great, welcome. It's good to have you. On that note, we're going to continue this next week. Thank you very much for going offline. See you tomorrow.